notes. Well, I do have 1 page of notes, but I don't have my notes with me because I promised you there would be no substance today. And that was a way to make sure that I kept to that promise. So don't ask me any substantive questions today, because I will give you that look that no law student ever wants to get. I will have a handout for you a little bit later that we'll talk about. But I have basically 7 things I want to say about my exams, about exam strategies, about the mistakes you can avoid. And of course, as we're going through these, if you have questions, ask them, right? It may be that I'll say, oh, I'm going to cover that in number 4, but hopefully we'll go through this. I don't think it will take the whole, what would normally be class time, but we'll see. We'll see. First of all, any questions in general before we get started? Not substantive in nature. Yeah?
We heard that you give a reading period.
Yes.
For the exam.
Like 30 minutes.
What do you recommend we do during that reading period?
That's number 5.
Oh, okay.
Well, we can start there if you like. There is a 30-minute reading period at the beginning of the exam. Check that off. During that 30 minutes, you cannot type in exam 4 if you're typing, and you can't start writing in a blue book. You can write on the exam itself, or you can write on scratch paper. So if you want to bring some scratch paper, that would be good. There's usually some in the rooms, like here, for example. And so you can mark notes in the margins saying, oh, this issue seems to be presented by this, or maybe this case is relevant to that. There will be at some point in the exam a choice of questions. On one of the 2 essay questions, you'll have some choice. Usually it's like an A or a B that you can choose from. So you can use that time to make your decision which of those 2 you want to do, so you won't feel like you're spending your 3 hours reading a question that you never answer, which can suck. Okay? So that's an option. Or what some people do with the 30-minute reading period is they do the multiple choice. Get that out of the way. Cautionary note. The instructions will tell you that you must mark your multiple choice answers in your blue books or type them in your exam 4. So make sure that if you use the 30 minutes when you can't do those things to do the multiple choice, that as soon as the time starts, as soon as we hit, the exam's at 9 in the morning? Or 9 in the morning? As soon as we hit 9:30, you mark your multiple choice answers that you just marked on your exam in your exam 4 or in your blue books. Because if you don't do that and then you forget later or you run out of time, you won't have any of the multiple choice done where they need to be done, and you'll get no credit for it. That's happened like 2 or 3 times, only 2 or 3 times in 15 years or so that we've had exam 4. But you don't want to be the 4th, right? And you can use the time that way. Just make sure, as I say, that you say, okay, now that I've got those answers, I say you can begin, that you mark those answers down, get it out of the way, and then you use the rest of the 3 hours just for the essay questions. That's certainly a possibility. The key is decide in advance what you're going to do with the 30 minutes. So you have a strategy. Whether you use it just for reading, whether you mark on the copy of the exam, you do what you're going to do and stick to your plan, because then you'll use that 30 minutes most efficiently. I will say this, whenever you're reading a question, whether it's during the 30-minute reading period or once the 3 hours has started, I think it is most efficient and useful for you to mark up as you go. Because if you try to read all through it, figure out what the question's about, decide whether you're going to do that question if you have a choice, and then, because then you're just going to go, if you don't mark up and remind yourself what the issues were and what you think you might want to talk about, you're going to do that, repeat that, and you'll use it, and you'll waste time. So when you're reading, as you're reading in the margins, write, oh, this seems to be about conspiracy. This seems to be about impossibility. This whatever, okay? So mark it as you go, and then as you go, when you come back to it and start answering that question, you'll know what you want to talk about. So that's how I would sort of think about it. But on the 30 minutes, decide before you come in for the exam, and then stick to that plan. Okay? Now, of all the things I'm going to tell you, I'm going to lead with, I was planning to lead with this, and then we'll lead second. Probably nothing's going to be more important than this. And it may seem obvious, but it isn't, unfortunately. And it's this. You're going to be lawyers. You're going to be having to know the rules and follow them. It begins with your first exams, right? I have had too many people not follow instructions and get penalized for it in various ways. And I don't want you to be, any of you to be the next person. For example, I tell you, since you're writing a memo, right? You're writing a memo. And so let's say I ask you to do that, and you put to whoever, let's say it's the boss, and you're a persistent Commonwealth's attorney, and I ask you to boss to a memo to the Commonwealth's attorney about what charges should be filed in a case. And then your next step is what's going to come next in your memo? From. And Mr. Johnson, what are you going to put there?
Not me.
Not your name. You can put your exam number, if you like. You can put some funny name that you think will amuse me, because I always like to be amused during exams. I'm a big Mets fan, so maybe you put Noah Syndergaard. Whatever. Maybe you put Dean Crawford. I don't care what you put, as long as it's not your name. Why don't I want you to put your name, Mr. Johnson?
Because that would mess up the anonymous grading.
Exactly. What will happen if you do that is you will get an irritated phone call from Dean DeSanza. Because I will have called her and said, it happened again. Somebody who is just so focused on getting their answers in, they just weren't thinking, and usually that's what it is. So we have a protocol now. She calls you in, she yells at you about compromising anonymity, which is technically an honor code violation. And she will tell you, there's going to be a note put in your file that this happened, so there'll be a record of it, and as long as it never happens again, there's no consequence to it. If it starts to happen repeatedly, then it starts to look like it's not inadvertent, right? But you do not want to get that call from Dean DeSanza. Does anyone here during finals period want to get that call? No. So follow the instructions. Don't use your name. Even more important than that, because that's annoying, but we can deal with it, is page and word limits. On most questions, I give a page limit if you're writing in the Blue Book of 8 pages, and a word limit of 12. If you're typing, a word limit of 1,200 words. Okay, and that's 8 pages, double spaced, writing only on one side of the page. Right? So follow the instructions and don't write on every line, because I will not be able to read your writing, most likely. If you write on both sides of the page, it all bleeds through, I won't be able to read it. I hate that. It gives me a headache, makes me annoyed, and you don't want me annoyed when I'm grading. Right? So 8 pages, every other line, one side of the page. 1,200 words. You know what the penalty is if you exceed the word limits or the page limits? Anyone want to guess?
You don't read past the...
That's half of it. I will not read anything past the limit. So if you have all your brilliant analysis after 1,200 words or on the 9th page, it won't matter at all. I won't read it. Because that's the equivalent of the court tossing your brief because you didn't obey some of the court's rules. What else do you think I do?
I was going to ask a question.
Well, okay, what else? Besides not reading it, what else do you think I do?
Me?
Because if you think that's all I do,
Take points off?
I take points off. Automatic 5-point deduction. So if you do it on both questions, 10-point deduction and losing the value of any analysis you gave on the page limits or word limits. Now, does anyone want to do that? No, I don't want you to do that. I hate, just last year, I had a student in con law who went double the word limit, more than double on one question and about a half again on the other question. Disaster. It's never happened before, anything close to that. It was awful. When I saw it, I was like, in disbelief. Don't be the next person who does that, okay? There is a word count function in exam 4. Turn it on and use it, okay? So that's the general point. Follow instructions. Don't cost yourself points for no reason. For no reason. Okay, question.
So is the 1200, is that for every question you've ever given, or is the limit going to be stated on the?
It'll state it on the exam. It'll be very clear. Word limit for this question. The vast majority of times I make them even. The two questions are even, each 1,200 words. Occasionally I make it a little different, and then the recommended time is usually 75 minutes for each of those two questions and 30 minutes for the multiple choice. That's if just using the 3 hours, assuming you only read during the reading period. Occasionally, I don't do it that way, and I make one question bigger than the other, and I'll make it 90 minutes and the other question 60 minutes, and then I adjust the word counts accordingly. But the total between the two questions will almost certainly be 2,400 words. Okay? That, by the way, encourages you to be concise, because I think that's good writing. I do not want you to just regurgitate everything, but I'll talk about that in a different way in a minute. But I want you to get to the point, I want you to make it clearly, and I want you to move on. And you'll have to do that because you won't be able to fit it in all you want to say unless you're being concise. You won't be able to fit it in 8 pages or 1,200 words. Okay? All right.
I have a question.
Oh, yeah.
Is the header included in that word count? Like the 2?
If it comes close, what do you mean the header?
The 2.
Oh, the to and from. What happens is if you come close to I know where in terms of number of pages typed, because I only use the word limit if you're typing. So let's assume you're typing. I know in exam 4 how many pages that translates into. So if you're close, then I don't count the header. And because what happens is I count the words. If you go onto the 4th page, depending on how you space and etc. If you go onto the 4th page, then you're cutting it close in an answer of 1,200 words. And if you go much onto the 4th page, then I count. So if you go a few words, a couple of lines onto the 4th page, then I know you're fine. But if you go well onto the 4th page, then I'm like, okay, now I have to count, which also is like, oh, great. But I count, because the rules are the rules. And then I don't count the header. But I don't even look at it if you keep it to 3 pages, if you only go a couple of lines on the 4, then you're fine. Yeah.
Basically, you want us to type double space? Or
If you're typing, I think there's a default. I think it automatically types double spaced. And then they print them out, because I get them printed out from IT.
If we know we're close to the word count, but we're not over, if we have the room, do you want us to put like word count 1189 or something like that?
No, you're fine. You don't need to do that.
What other formats besides memo format do we need to be familiar with?
Well, I may ask you to do one of several things. I may ask you, memos is one. I may ask you to write an opinion, right? An opinion as a judge. And so, how many opinions have you read this semester? I'm sorry? Ballpark?
Too many.
Who said too many? Too many? Hundreds, right? My recommendation is you think about which opinions did you read in any class, not just criminal law. Which opinions did you read that you thought were clear, that you thought were persuasive to you, even if you didn't end up agreeing with them, but they were persuasively argued by the court, right? That you thought, wow, that was effective explanation of the position the court took and why it reached that result. Those should be your model.
So
Right.
not Cardozo.
I'm sorry?
So not Cardozo.
Ouch. And poor Benjamin Cardozo is now crying in his grave. Right? Whoever, right? Maybe you, I don't particularly recommend trying to replicate 17th or 18th century England, courts of England, because that's A, that's hard to do, and B, it might be amusing. I actually did that in torts. In my first year torts class, I decided the exam my professor wrote the exam in sort of an old English style, the question. And I was like, okay, fine, you want to play games? And so I wrote my answer that way, and he was amused. But anyway, I don't recommend that. Because I won't ask a question that way, I promise. So don't answer that way. But find an opinion or three that you really liked, and say, oh, okay, that's how I should write an opinion if I'm asked to do that. Right? That's how a judge does it. That's the tone a court tries to communicate. And so you've seen enough opinions, think about it that way. Call?
Should we do a fact section in our?
You will never have to do a fact section. Speaking of following directions, there will be an instruction on the front page of the exam. Actually, there'll be a whole list of instructions, because I'll hand out the exam like 15 minutes or so before 9 o'clock, and you'll be able to read the front page. Read those instructions carefully. Don't just ignore them. That's why I hand out the exam earlier so you can look at those. One of them will be on any document on which you would ordinarily include a statement of facts, don't. Because I don't want you to waste your time. I know the facts, and I want you to get to the argument. So you will not have to include a statement of facts. Okay? And that includes a judicial opinion. I may ask you to do an opening or a closing. And how many times in here have I said, how would you argue this to the jury? And then I'll ask you, and most of you are like, I don't know. And I'll say, ladies and gentlemen of the jury, the judge has instructed you, blah, 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 blah. I want you to think in those terms. How would you argue? You tell the court, you tell the jury what the facts were, and why they should see the facts in a certain way, and how the law, because you'll show them you know the law that applies to that particular charge, how the law and the facts fit together. We ask you, ladies and gentlemen of the jury, you should acquit my client because these facts do not add up to the elements of this charge beyond a reasonable doubt. So you'll give that statement.
So with the opinion and the open closing statement, you want us to be persuasive, but with the memo, do you want us to be sort of impartial?
I cannot emphasize this enough, and I'll talk about this separately, but I cannot emphasize this enough. All legal writing is or should be persuasive. All. I don't care if it's a memo. I don't care what it is. If you're not being persuasive, you're not being a good lawyer. No matter what law, no matter what role the lawyer is playing. Okay? This is, if I have any central philosophy as a law teacher that I want to communicate, I mean, how many times have I sort of talked in here about be persuasive? Those of you who've done practice questions and handed them in for comments. Many of you have got, how many of you have gotten back somewhere in your comments, be more persuasive, don't be descriptive? Okay? That's what I want. And I'll talk about how I would approach doing that in a minute. The idea of descriptive writing, to me, is a non sequitur when it comes to legal writing.
How did you say again that we're supposed to handle like the counter arguments if we're taking?
I'll talk about, let me talk about that in a little while. Okay? But let me go to this. One, and this is all of a cluster of things about being persuasive, so it's a natural transition. The first thing that helps make you persuasive, I think, is to address and answer the question I ask. And provide the answer up front. Right? If you don't provide the answer up front in your intro of whatever document you're writing, then you're not being persuasive. How do I know that? Because if you don't tell me what the answer is, what your conclusion is, then how can I be persuaded? Because you're not telling me what I'm supposed to be persuaded to agree with. Right? If you just tell me what the issue is, then it's like, okay, I know the issue, but I don't know what you're telling me I should believe. If you're the Commonwealth's attorney, writing a memo to the Commonwealth's attorney, and you're saying, we should charge these 4 potential defendants with the following crimes, then you're telling me what I should believe. And then I'll know in the rest of the memo, okay, this is what he or she, what they're trying to persuade me of. But if you just start with the events of January, let's say I give you a hypo where the events all took place on January 31st. The events of January 31st give rise to a number of potential charges against each of the potential defendants, which I will address in turn. If you told me anything that I can then say, okay, now I know what they're going to talk about, and I can be persuaded of that, you've accomplished nothing. It's purely descriptive, and it's a waste of your word count. Start off with your position up front, and then spend the rest of the whatever it is persuading me. If you're writing an opinion, we hold today that the conviction of Ms. Harper, say I put Ms. Harper in the hypo, and she's one of the people who's been charged and convicted. I do sometimes put you guys in the hypos,
As long as it's murder.
just to let you know.
As long as it's murder.
That the conviction of Ms. Harper should be affirmed because there was no error in either the jury instruction or the admission of evidence. The defendant appellant's argument that the court erred in failing to give an instruction on EED is unpersuasive. Right? You've told me what the issue is and what your conclusion is as the court. There didn't need to be an instruction on EED. So I know what the issue is, and at the same time I know your position. You don't have to tell me Ms. Harper, the defendant, raises the question of whether an instruction on EED should have been given. That's descriptive. If you say, we reject her contention that an instruction on EED should have been given, you told me what the issue is and your position at one time. Everyone see the difference? How you're doing it in a more persuasive tone when you state the position as you state the issue up front. And it doesn't matter what kind of document you're writing. A memo is the same as an opinion in that way. Is the same as an opening or closing statement. They're all meant to be persuasive to the reader. So you've got to tell them what your position is that you're trying to persuade them of. Okay? In addition to being persuasive, to giving the position up front, only answer the question that I asked. Do not bring up a bunch of extraneous stuff just because you have it in your notes and damn it, you're going to tell me about it. I do not like kitchen sink answers because kitchen sink answers don't show me that you can separate out relevant versus irrelevant. One of the skills that I want you to show me you have in your arsenal is to distinguish relevant and irrelevant. The way you do that is by not bringing up the irrelevant stuff. Just don't even bring it up. If you bring up irrelevant stuff, the best that can happen to you with the irrelevant stuff is that if you get it exactly right, you bring up this whole issue that's completely beside the point, just to tell me, oh, by the way, this case doesn't raise any issue of felony murder because felony murder doesn't exist in Kentucky, and in any event, the defendant's actions weren't wanton, so we don't have to consider felony murder. Why would you do that? Other than to show me, oh, I know the rule about felony murder in Kentucky, as if I'll give you points for that when it has nothing to do with the question. You're not answering my question, and you're not being persuasive on the issues that should be addressed, right? I want you to show me by simply not bringing it up that irrelevant stuff isn't your job. As a lawyer, when a client comes into your office and says, here's what happened to me, they want you to be able to hear that, maybe then do a little research and say, okay, you don't face any, the only risks you face are maybe tax fraud and obstruction of justice. You're not going to talk to them about murder when there was no death. Oh, here's the good news, you don't face any murder charges. And they're like, what? Why are you bringing that up? Right? Bring up what's relevant. Bring up what's relevant. Now, that can be a hard task, because some of you are going to sit there during the exam and you're going to say, you know what, I think he means to get at this. Should I raise it? Should I not? Well, here's the standard you should be applying. Raise it if it's plausible. And if you can explain why it's plausible, let's say it's a charging memo, and you were the Commonwealth's assistant Commonwealth's attorney, and you say, well, I think we could have charged X, because it may be plausible on the facts, but I'm not going to bring that up. Explain why if it was plausible. If it wasn't, it was completely implausible, then don't. And then hopefully you'll use good judgment in drawing that line. But that's what your standard should be, plausibility. Anything that's a plausible argument, bring it up. Anything that's so implausible, cast it aside and focus on the point.
So say we're like asked to be a defense attorney and like kind of in one of the hypos, and they're asking us like what's gonna happen, like what charges they're likely to face. Should we be like, well, the prosecution may bring this charge and this charge depending on like which one they're like the jury finds? Like if they
Well, they don't have the jury verdict yet. Remember, the prosecution's thinking about charging
yeah.
before they ever have a jury. They're thinking, what do we think we can prove beyond a reasonable doubt to a jury, and perhaps what might we bring strategically to have leverage on plea bargaining, right? So remember, there's a difference between saying this is what they may charge and this is what you'll be convicted of, and that you should be. I mean, if I ask you to address both, right? If I say, what is your client like to tell your client what he or she is likely to be charged with, or they, might be more than one, and tell them what you think the likely outcomes are. If I ask you for the likely outcomes, keep in mind that you should be discussing plea bargaining, right? Well over 90% of cases end with plea bargains. So if you don't talk about plea outcomes or potential plea outcomes, then you're not talking about likely outcomes, right? So you could say, they will charge you with this, you're in trouble on this, but we'll seek to bargain it down. If you're the defense side, we'll seek to bargain it down to this lesser charge. To get that, we may have to compromise on one of the other charges, because it's a negotiation, right? If you're the prosecution, you would say, well, we'll charge this. It may be questionable whether we can get a conviction, but it gives us leverage so that if we have to agree to a lesser charge, then the defendant will have given something and we can get something else in exchange. Talk about that. We've talked about it in class. Put it to use.
Kind of continuing of maybe charges to be bring up. So I guess more to narrow that. So let's say then that there's a charge or there's a statute that could be brought up, or a section of the ARS that contains lesser related offenses. If it's plausible that they could be brought up, but they probably won't be, we should still explain why they won't be brought up.
If it's plausible.
If it's plausible.
Right.
Okay.
And of course, mention if it's a lesser included offense, they may, let's say you're the defense.
Right.
If it's a lesser included offense, you should say they may charge you with this, both kidnapping and unlawful imprisonment, for example. But if you're convicted of both, you can only be punished and sentenced for the greater charge. That's part of what is a lesser included offense, right? So, but they may charge you with both, and again, we've talked about this tactically because they're not sure they can get the greater charge, right? So they want to make sure it's not all or nothing, because they may get nothing, right? Yeah.
So going with the plea bargaining part, if we're asked to write a memo, should we put that in our conclusion after we analyze what could happen and kind of say, like, this is what we should do, and if that is the course we go, then this is what could happen?
I think there's different ways to handle that. You might want to go charge by charge. right? So let's say there's a murder or at least a homicide charge in there, and you have a pretty good argument for self-defense, right? You could say, they will charge you with murder, but we have a strong self-defense argument, which if we win, would result in your acquittal, but they'll argue that it was an unreasonable belief, which can maybe will only mitigate it down to reckless homicide. So we will try to plea bargain perhaps for something in between. So you might want to, if it's sort of self-contained and is not part of the negotiation of all the charges, maybe if that's the reason, you want to discuss it right there, because there's a factual question on which there's a dispute that could lead to a compromise on that one charge. But if it's part of an overall package where you say something like, well, we want to get murder off the table because it's a capital crime and that's a really high priority for us, and so we may have to compromise on the other crimes that you're charged with in order to get the prosecution to come down off of murder down to manslaughter, then you might put it at the end because it's part of balancing all of them. So think about how you can best make the point. And that leads to another point, which again was not necessarily where I was going to cover it, but outline. You will think inevitably, oh my God, I'm not writing, I'm just outlining, right? And it's like you want to get writing because the clock is moving. And believe me, that clock is going to be moving to you so fast. Like, oh my gosh. It's like if you're a sports fan, you know that when your team is winning, the clock in the last few minutes of a game seems to take forever. And if your team is losing, it goes like that. Am I wrong? Right. This will be like, oh my God, the clock is just zooming because I need more time. It is still worth it to outline because it will make you better organized, more efficient, and avoid repetition. And if you avoid repeating yourself, you avoid disorganization, you'll actually write faster. That investment of time in outlining will actually make your job easier and you'll use the time better. I cannot strongly enough. Now maybe you're one of those rare people who can outline in their head right from the outset of when you see a question and it just comes naturally to you. Wonderful. You're the exception. Ignore what I just said. I doubt that's true for most of you. It's certainly not true for me, right? When I would write an exam answer, I would sort of try to outline, here's what I'm going to talk about, and here's the order I'm going to cover them. In general, I strongly suggest that if you're making policy type arguments, like the Burns hypo, where I asked you to talk about the purposes of punishment and whether extraditing Burns would serve the purposes of punishment, I strongly recommend that when you outline and when you then write, you go with your strongest arguments up front and your weaker arguments at the end. Okay? So that's part of the outlining process and then the organizing process. Now, as to dealing with counter-arguments, speaking of your weakest arguments at the end, instead of saying, let's say I make you, in the Burns situation, you want to argue that Burns, and you're on the side of Burns, should be extradited. Okay? One of the counter arguments to the Burns should be extradited side that the no extradition point people would say is that extraditing him would totally undermine the value of rehabilitation because it would send the message that rehabilitation is meaningless, rehabilitation won't be rewarded, and that we don't value rehabilitation, and it would undermine the purpose of rehabilitation. Now, you could answer that by saying those who advocate extradition claim, I'm sorry, those who oppose extradition. Oops. Claim that that is extradition, would undermine the goal of rehabilitation. And then you answer that. But look what that sentence has just done. You've stated the other side's position. You've used your memo, your words, to give the other side's point of view. You never want to do that. Right? Let them use their memo to say that extradition would undermine the goal of rehabilitation. Right? That's their job. How do you turn that around? Just state it affirmatively. Extradition would not undermine the goal of rehabilitation. Right? State it affirmatively. Now you're telling me your position on the relationship between extradition and rehabilitation. And you're telling me it wouldn't. Or maybe your position is, while extradition would have some negative effects on rehabilitation, it is still worth it because that is counterbalanced by the other goal. Whatever your position is, but you're stating your position, not responding to the other side. This, when you do it the way I've crossed out, is defensive. Avoid being defensive. Affirmative writing is persuasive writing. Okay? If you find yourself stating the other side's position, or if you're writing an opinion, stating the argument you've rejected in order to respond to it, it's a natural thing because you're thinking, well, here's all the counter arguments, I need to deal with them, so let me state them first. But state them in this way, and you'll be more concise, you'll get to the point quicker, and you'll have a more persuasive tone. I will be a happy, happy grader if I see lots of this. And I'll be like, no, if I see lots of this. Okay? Okay. Got that. There's no kitchen sink. Oh, open book. This is an open book, open note exam. Right? You can bring your textbooks. You can bring and should bring your KRS excerpts, which you should print out. Okay? And you can bring your notes and outlines. Anything you participated in. If you're in a small group and you all have a joint outline, that's great. Anything that somebody else prepared, that you were involved in preparing, commercial study aid, for example, don't cut and paste that into your outline. That's off limits. Okay? It's an open book, open note exam. That can be a trap, as Admiral Akbar might say. Okay? That can be a trap because you'll spend so much time looking through your notes and, oh, I know that's here somewhere. What case was that? And through the case book, the time will melt away. So you want to be strategic in how you use that. I give an open book / open note exam because that, to me, it best replicates, at least in the exam setting, what lawyers do. No lawyer I've ever known, ever, says, client comes in, has a problem, relates to you the facts, and the lawyer says, well, let me try to get the right answer, and what I'll do is I'll shut myself off from any resources and look at nothing in order to find out what the right answer is. Right? Lawyers look at material and say, here's what I can find that answers your question or helps solve your problem. So we're going to look at the material. In doing so, make sure that your outline is well suited, not just to study from, it should be that too, obviously, because you want to use it for studying over the next couple of weeks, but to be used in the exam setting. And by that I mean, or at least what I think works for most people, is to organize your outline conceptually, not like case by case by case. Right? Because what happens is you get the exam and you see, oh, this question clearly is about attempt. Because this clown tried to do something and messed it up. Right? So I don't have a completed crime, but the question is, did they do enough? Was it a substantial step? Blah, 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 blah. So you note in the margin when you're reading through it, attempt. I see an attempt issue here at least. Now how are you going to resolve that? You may not know as you're reading through it the first time, but you flag the issue. So you want to be able to immediately go to your outline and know where attempt is. And that's one of our concepts, right? And so go to attempt and to see which cases there and what the material is, and then which cases support arguments about attempt. And you see, oh, this is about substantial step. So in your attempt outline, you have the issue of substantial step under the Model Penal Code, what that means, and which cases we read. And then you can go use that and then what pages they're on. And then you can go to the case book from there. And you have an efficient process. right? And maybe you organize it so you have the cases listed for whether they help the defendant or whether they help the prosecution in terms of this whole issue of substantial step. And so if I make you the prosecutor and you want to argue that it was an attempt, you'll say, this case is really good for that, because my notes tell me that. So organize by concept. So have, a section on attempt, or a section on conspiracy, a section on impossibility, a section on actus reus, etc. If you organize it by case, that is just going to be a nightmare trying to utilize it during the exam. Okay?